Case 38, U.S. versus Varig Airlines. We find ourselves in the Supreme Court of the United States. Facts. On July 11, 1973, a commercial jet aircraft owned by respondent Varig Airlines was flying from Rio de Janeiro to Paris when a fire broke out in one of the aft lavatories. The fire produced a thick black smoke, which quickly filled the cabin and cockpit. Despite the pilot's successful effort to land the plane, 124 of the 135 persons on board died from asphyxiation or the effects of toxic gases produced by the fire. Most of the plane's fuselage was consumed by a post-impact fire. The aircraft involved in this accident was a Boeing 707, a product of Boeing Company. In 1958, the Civil Aeronautics Agency, a predecessor of the FAA, had issued a type certificate for the Boeing 707, certifying that its designs, plans, specifications, and performance data had been shown to be in conformity with minimum safety standards. Seaboard Airlines originally purchased this particular plane for domestic use. In 1969, Seaboard sold the plane to respondent Varig, a Brazilian air carrier, which used the plane commercially from 1969 to 1973. After the accident, respondent Varig Airlines brought an action against the U.S. under the Federal Tort Claims Act, FTCA, seeking damages for the destroyed aircraft. The families and personal representatives of many of the passengers, also respondents here, brought a separate suit under the Act, pressing claims for wrongful death. The two actions were consolidated in the U.S. District Court of the Central District of California. Respondents asserted that the fire originated in the towel disposal area located below the sink unit in one of the lavatories, and alleged that the towel disposal area was not capable of containing fire. In support of their argument, respondents pointed to an air safety regulation requiring that waste receptacles be made of fire-resistant materials and incorporate covers or other provisions for containing possible fires. Respondents claimed that the CAA had been negligent when it inspected the Boeing 707 and issued the type certificate to an aircraft that did not comply with CAA fire protection standards. The district court granted summary judgment for the U.S. on the ground that California law does not recognize an actionable tort duty for inspection and certification activities. The district court also found that even if respondents had stated a cause of action in tort, recovery against the U.S. was barred by two exceptions to the Act: the discretionary function exception and the misrepresentation exception. The U.S. Court of Appeals for the Ninth Circuit reversed. The Court of Appeals reasoned that a private person inspecting and certificating aircraft for airworthiness would be liable for negligent inspection under the California Good Samaritan rule, and concluded that the U.S. should be judged by the same rule. The Court of Appeals rejected the government's argument that respondents' actions were barred by 28 U.S. Code 2680, which provides that the U.S. is not subject to liability for any claim arising out of misrepresentation. Interpreting respondents' claims as arising from the negligence of the CAA inspection rather than from any implicit misrepresentation in the resultant certificate, the Court of Appeals held that the misrepresentation exception did not apply. Finally, the Court of Appeals addressed government's reliance upon the discretionary function exception to the Act, which exempts the U.S. from liability for claims based upon the exercise or performance or the failure to exercise or perform a discretionary function or duty. The Court of Appeals viewed the inspection of aircraft for compliance with air safety regulations as a function not entailing the sort of policymaking discretion contemplated by the discretionary function exception. On October 8, 1968, a de Havilland Dove aircraft owned by respondent John Dowdle and used in the operation of an air taxi service caught fire in midair, crashed and burned near Las Vegas, Nevada. The pilot, co-pilot, and two passengers were killed. The cause of the crash was an in-flight fire in the forward baggage compartment of the aircraft. The de Havilland Dove airplane was manufactured in the United Kingdom in 1951 and then purchased by Air Wisconsin, another air taxi operator. In 1965, Air Wisconsin contracted with Aerodyne Engineering Corp. to install a gasoline-burning cabin heater in the airplane. Aerodyne applied for and was granted a supplemental type certificate from the FAA authorizing the installation of the heater. Aerodyne then installed the heater pursuant to its contract with Air Wisconsin. In 1966, relying in part upon the supplemental type certificate as an indication of the airplane's airworthiness, Respondent Dowdle purchased the de Havilland Dove from Air Wisconsin. In the aftermath of the crash, Respondent Dowdle filed this action for property damage against the U.S. under the FDCA. Respondent insurance companies also filed suit under the Act, seeking reimbursement for monies paid for liability coverage on behalf of Dowdle. The U.S. District Court for the Southern District of California found that the crash resulted from defects in the installation of the gasoline line leading to the cabin heater. The District Court concluded that the installation did not comply with the applicable FAA regulations and held that the government was negligent in certifying an installation that did not comply with those safety requirements. Accordingly, the District Court entered judgment for respondents. On appeal, the U.S. Court of Appeals for the Ninth Circuit reversed and remanded to the District Court to consider whether the California courts would impose a duty of due care upon the government by applying the Good Samaritan doctrine. The Court of Appeals also requested the District Court to determine whether, under the facts of this case, the California courts would find such a duty breached if a private person had issued the supplemental type certificate in question here. On remand, the District Court again entered judgment for respondents, finding that the California Good Samaritan rule would apply in this case and would give rise to liability on these facts. On the government's second appeal, the Ninth Circuit affirmed the judgment of the District Court. In so holding, the Court of Appeals followed reasoning nearly identical to that employed in its decision decided the same day. So what is the issue now before the U.S. Supreme Court? Whether the actions were barred by the discretionary function exception of the FTCA. Holding. The court held that the actions are barred by the discretionary function exception of the FTCA. Let's look at some reasoning here. And let's first define some terms. In the Federal Aviation Act of 1958, Congress directed the Secretary of Transportation to promote the safety of flight in civil aircraft in air commerce by establishing minimum standards for aircraft design, materials, workmanship, construction, and performance. Congress also granted the Secretary the discretion to prescribe reasonable rules and regulations governing the inspection of aircraft, including the way such inspections should be made. Congress emphasized, however, that air carriers themselves retained certain responsibilities to promote the public interest in air safety. The duty to perform their services with the highest possible degree of safety, the duty to make or cause to be made every inspection required by the Secretary, and the duty to observe and comply with all other administrative requirements established by him. Congress also established a multi-step certification process to monitor the aviation industry's compliance with the requirements developed by the Secretary. Acting as the Secretary's designee, the FAA has promulgated a comprehensive set of regulations delineating the minimum safety standards with which the designers and manufacturers of aircraft must comply before marketing their products. At each step in the certification process, FAA employees or their representatives evaluate materials submitted by aircraft manufacturers to determine whether the manufacturer has satisfied these regulatory requirements. Upon a showing by the manufacturer that the prescribed safety standards have been met, the FAA issues an appropriate certificate permitting the manufacturer to continue with production and marketing. The first stage of the FAA compliance review is type certification. A manufacturer wishing to introduce a new type of aircraft must first obtain FAA approval of the plane's basic design in the form of a type certificate. After receiving an application for a type certificate, the Secretary must make or require the applicant to make such tests during manufacture and upon completion as the Secretary deems reasonably necessary in the interest of safety. By regulation, the FAA has made the applicant itself responsible for conducting all inspections and tests necessary to determine that the aircraft comports with FAA airworthiness standards. The applicant submits to the FAA the designs, drawings, test reports, and computations necessary to show that the aircraft sought to be certificated satisfies FAA regulations. Type certificate. One major manufacturer of commercial aircraft estimated that while obtaining a type certificate for a new wide-body aircraft, it would submit to the FAA approximately 300,000 engineering drawings and changes, 2,000 engineering reports, and 200 other reports. In addition, it would subject the aircraft to about 80 major ground tests and 1,600 hours of flight tests. During the type certification process, the manufacturer produces a prototype of the new aircraft and conducts both ground and flight tests. FAA employees or their representatives then review the data submitted by the applicant and make such inspections or tests as they deem necessary to ascertain compliance with the regulations. If the FAA finds that the proposed aircraft design comports with minimum safety standards, it signifies its approval by issuing a type certificate. Production certificate. Production may not begin, however, until a production certificate authorizing the manufacturer of duplicates of the prototype is issued. To obtain a production certificate, the manufacturer must prove to the FAA that it has established and can maintain a quality control system to assure that each aircraft will meet the design provisions of the type certificate. When it is satisfied that duplicate aircraft will conform to the approved type design, the FAA issues a production certificate and the manufacturer may begin mass production of the approved aircraft. Airworthiness certificate. Before any aircraft may be placed into service, however, its owner must obtain from the FAA an airworthiness certificate, which denotes that the aircraft in question conforms to the type certificate and is in condition for safe operation. It is unlawful for any person to operate an aircraft in air commerce without a valid airworthiness certificate. An additional certificate is required when an aircraft is altered by the introduction of a major change in its type design. To obtain this supplemental type certificate, the applicant must show the FAA that the altered aircraft meets all applicable airworthiness requirements.